Hannah, thank you. Queen City News and Chief Legal Analyst Khalif Rhodes has been reviewing the justices' opinions all day for us, all 237 pages of them. So, Khalif, of course, this is a massive decision by the majority conservative court. What sticks out most to you in reading those rulings?
Well, I mean, they obviously attacked the 14th Amendment, or used that, I should say, and utilized the 14th Amendment as a grounds for this being something that is not equal, the 14th Amendment being an equal protection clause. The irony about that, and that's, I think, what sticks out to me most, is that that clause in these types of laws were utilized to actually help African Americans and people of color equal the playing field. And now, as we get further and further away from those eras of civil rights, the distance, I think, allows us to forget what happened in between that time. And so now they flipped the tables and actually have now used the same amendments that were used to open up the doors to now somewhat close them on certain segments of society, for sure.
And in Hannah's story that we just heard there, someone mentioned, that a majority of Americans want this and that they would potentially be happy with this ruling. So what do you have to say about that?
He said that most people would want this in regardless of race. And I think the majority statistically probably would be behind that if that's his argument. 76% of America is white. But there is 13% of America that I think is probably looking at this from a different angle than the individual mentioned on there today. It isn't eroding and a peeling back, as Justice Sotomayor said. We're taking a number of steps back with this colorblind approach, because we live in a society that is not colorblind. And if we're attempting to address the past, as even these lawsuits didn't do, but if we're attempting to address the disparity or the disparate impact that other folks have had with getting access to college, and then we're encouraging colleges to have diverse campuses, this doesn't get us there. This gets us further away from there. She says a superficial rule of colorblindness in an endemically segregated society, that's what the court in this majority opinion is trying to push forward. And I totally agree with her.
Well, and of course, people are wondering here, okay, this is 237 pages of rulings. This is what your decision is. But how does this impact me? In the Carolinas, we have dozens of colleges and universities. How does this change the landscape of the admissions process for students who are going to apply to school?
Well, I think obviously superficially on the checkbox selection. So if you're checking a box to determine a person's race, removing that portion will be the first part. Getting an additional point in terms of the admission process, you won't be getting an additional point in terms of criteria just based on race. And so I think immediately there, that will impact anyone that's applying to colleges that may have in the past received an additional or leg up or an evening of the playing field. That portion is now removed for sure.
And the colleges are going to have to start working on taking all those applications and changing them. So we'll be hearing a lot more of this in the coming days. Our Chief Legal Analyst, Khalif Rhodes, thanks so much for joining us. Tara?